Okay. 25T01947FY, People of the State of Michigan versus Robert Wayne Sigsbee. Counsel, if you can place your appearance on the record, please.
Good morning, Your Honor. Kent Wallace on behalf of.
And Mr. Sigsbee, can you state your name?
Robert Sigsbee, Executor, Beneficiary Trust.
All right, thank you. Okay, we are here today on a PCC. I know that there have been some discovery going back and forth. Last time, actually, we were scheduled for an exam and one of the police witnesses had an injury and couldn't be in court. That's what my notes state, and so we set it for a probable cause conference for today. We're back today. I am hoping that both parties are going to tell me that we're ready to set this for exam again and that there are no further issues.
Yeah, so Your Honor, to start, regarding the discovery, I have just provided Mr. Sigsbee with a flash drive that should have all of the requested discovery on it. There is a proof of service given to Mr. Sigsbee, and I asked if I could approach to give one to the court for the case file.
All right, thank you.
Thank you, Your Honor. As for an exam, I have been able to talk to Sergeant Lenowitz regarding the officer. He is able to attend court now, so we are ready for an exam date.
All right.
And we would just ask that at the end of December. That's the only, he needed like another week or something before he was able to walk, so we would just ask that it be set for a December date.
Mr. Sigsbee?
Well, I'm gonna need more time, because I'm gonna need time for this FOIA. To the Treasury of the United States, I request you for your W-9 and the court's EIN number, according to 26 U.S.C. 6903. And I think I feel I need to submit to the IRS a 3949A form on what's happening here. So I'm gonna need to see a copy of your W-9. Can you say that on the record, please?
I will, but I'm waiting for you to finish.
Thank you. That is elegant. Thank you kindly. And, I'm looking for a dismissal for this frivolous cause under 12B of the Federal Rules of Civil Procedures. All of them, all 7, are being violated right here on its face. So I'm going to need to request your W-9 and the court's EIN number. This is a taxable event. And, I need to submit a 3949 to the IRS. I need time to send to a FOIA to the Treasury of the United States under 26 U.S.C. 6903 for the record, to be reserved on the record to correct the record.
Okay, all right, so your request for a W-9 or an EIN for me, that request is denied. That's not necessary nor relevant. No, I don't even know if I have an EIN. I don't think that I do.
You do.
No, don't interrupt me, please remember.
I apologize.
I don't know, the court might have one because the court actually has employees, but I don't have employees, so I don't have one. But either way, the request is denied. It is not relevant to this case and it is not necessary. And frankly, it's not anything that you need really in any situation involved in this case. The request for dismissal is also denied. There are no rules being violated here. In fact, the court has been more than lenient with you, Mr. Sigsbee, on your requests and different things that you stated and filed and everything. And so that request for the dismissal is denied. Rules of federal civil procedure don't even apply in this hearing. And so, those rules are irrelevant. I encourage you, though I'm not giving you legal advice in any way, I encourage you to focus on the Michigan court rules that apply to this hearing. Those would probably do you better to quote than the federal rules of civil procedure. As far as a FOIA to the federal government, I'm not waiting on a FOIA to the federal government. I don't even know how long that would take, and I do not believe it is relevant because, again, you're talking about tax issues and things like this, and we are on a case that involves a count of assaulting, resisting, or obstructing the police, bringing contraband into a prison, and driving while license suspended. And so I am going to give you time, as I have in the past, so that you can be prepared, but I'm not going to grant the request to just simply adjourn until you can get the information you just stated, because that information is not relevant to this proceeding. So here is what I am looking at in regards to a date. I want let's see. So, Mr. Sigsbee, if I were to put this in January as opposed to December, would that make you happier?
It is fine with me, even though I am objection under special restriction appearance that, there has been substantive due process violations across the Constitution and the laws of the United States on its face, including the Fifth Amendment. My private property was taken without just compensation. The due process of, there was never an indictment. This is a probable cause conference, and that's not suffices to satisfy constitutional substantive due processes that have been violated. And in the 11th Amendment, foreign citizens cannot invoke the judicial system of the United States. And once again, I can read off every way that you guys are foreign, right here, easy enough. We have, so we're looking at, under 4J, Federal Rule of Civil Procedures, all courts, jurisdictions, and immunities fall under foreign state 22 U.S.C. 92, 12 through 13, foreign relationships. Once an oath is required, it takes an oath of office to be required. 11th Amendment, foreign citizens are not, cannot invoke the judicial powers of the state. That's 28 U.S.C. 3002-15A, the definition of the United States means a federal corporation. Foreign Sovereign Immunity Act 1976, 1605 through 1608. The government is liable for violating the sovereign people's rights. And again, under Trinity versus Pegularo, anything that the prosecutor says and puts on the record is to be struck. Attorneys cannot give testimony or be a witness in a court case, and I do believe that has happened here too. So,
which is number one, wrong.
So we have mass violations of the Constitution and the laws of the United States. And I'm going to need to see your foreign agent registration supplements and your filings with the Attorney General of the United States. I gave you a judicial notice, and no one, not the clerk, not the judge, not the prosecutor, not the false impersonating prosecutor, has showed me a shred of anything. This is false impersonation of a government actor under 18 U.S.C. 912.
Okay. The other issues that Mr. Sigsbee brought up earlier, he's brought up on a couple different occasions. That's why I didn't really give you a chance to speak, Attorney Wallace. I apologize, but I believe I made rulings on those things before as well. Was there anything you wanted to say in response to what you just said?
No, Your Honor, I think that this has been discussed on the record multiple times. I think every time that we've been on the record in this case, I think the people's position has been made clear on their statements.
All right, thank you. And so I will say one more time, there have been no due process violations in this case that I have seen or that have come to my attention. There is no requirement for an indictment in this case. That's not how this process works in the state of Michigan. We don't do indictments. They do a warrant and complaint that is reviewed by the judge and then signed by a judge, and then it goes to the arraignment phase, and then it goes to the probable cause phase, and then it goes to the exam phase, and then it goes to the trial phase in circuit court if it gets past the preliminary examination. But we do need to have that preliminary examination. We are going to have that preliminary examination in January. When we get to the preliminary examination date, I will, the request for the other documentation is denied as well. Again, completely irrelevant to this case, and I'm not going to entertain those type of requests. And I do want to tell you, Mr. Sigsbee, when we come back for the exam date, I am not going to entertain a restatement of the arguments that were made today. So if you want to make a new argument about new issues, I'll allow you to do that, but we're not going to go over these things again. We're not going to talk about EIN numbers and all this other stuff that you talked about. We're not going to do that, just like we're not going to go over this stuff because I have already addressed the other motions that were filed. So we're not rehashing things. We simply do not have the time to do that. We need to get this exam done. So I am looking at, how would everyone feel about January 20th at 1:00 p.m.?
I'm objecting to any kind of court date, obviously.
I'll note your objection.
I know you will.
Free
I know
on
you will.
January 20th at 1:00?
Elegant would work. Yeah, can I get that in writing?
That works for the people, Judge.
Okay, so we will set this for preliminary examination, and we will get you a written notice today before you leave, Mr. Sigsbee. January 20th, 2026, if you can believe it, at 1:00 p.m. All right?
Preliminary exam.
Preliminary examination, so make sure to bring documentation witnesses. That's the time when I'm gonna hear those things, to establish whether or not there is probable cause to believe that a crime exists or a crime has been committed. A crime has been committed by you, Mr. Sigsbee, and has been committed in this venue being Genesee County. And if probable cause is established, then the matter will move on to your actual trial in the circuit court, if probable cause is established.
Thank you, Your Honor.
Good? Okay, thank you, everybody. I did. Oh, I understand it. I'll give it back to you.
Take care, buddy.
And excuse me if I'm a Matlock fan.
Oh, that was pure fun. That was pure fun. I have to thank Brecken for putting that together for me, and also Page B, who apparently scoped that out. They're at fault. I've got more stuff. I was putting some stuff together, and then I had a subset emergency in the middle of it. So I've got a couple more good clips. Once I've called the crowd together, why not? Let's do it, shall we?
Show up, right?
Right.
You just took off because you didn't want to come, or what?
No, it wasn't that I didn't want to come. I was in between the places I was living at, and my leg was broke. I was trying to take care of that. I didn't want to come to jail without having a cast put on it, but I couldn't get a cast put on it. It just, like I said, it just spiraled.
So you just
spiraled up.
disappeared for 5 months.
I didn't even know anybody was looking for me.
Now,
For 5 months.
how is it, you were told when you were here December 16th, when you were over in probation, you were given an appointment to come back to complete your interview, right?
I'm not sure.
You're not sure. Okay, well, let's take a look. I'm sure, but let me just say what you said. You were given, when you went over there on the 16th of December, you were given some papers to fill out. And one of the things that you were to fill out was your written version of what occurred with this offense. And you put, "Will explain and write out when I return on December 30. So your appointment to come back was December 30. You knew that because you wrote that. And you specifically did not come back on December 30. Did you say to the probation officer that, look, can I come back some other time because I got my leg broken thing and I want to get that taken care of. Can I come back at a different time?" You didn't.
I should have said that. I'm not
Right,
sure
you
if I did or
didn't.
not.
You
Okay.
just took off, okay? You took off knowing that you had taken drugs and were going to test positive, so that's kind of probably why you didn't come back.
I don't remember not
You
coming
know,
back
I
to the
remember.
appointment. I just remember that it was sentencing.
You don't remember,
That's kind of probably why you didn't do it. It's so therapeutic watching Judge O'Donnell. I just took out the good bit. This is a much longer hearing, but this is my favorite part.
a lot of things, okay? That's what prolonged drug use will do, is you start to forget a lot of stuff. Okay? So, how is it that you came back on May 19th?
How did I come back on May 19th
Yeah,
to jail?
yeah,
I was arrested for driving under suspension.
okay. So, you didn't turn yourself in.
No, I already did that last year.
You did what last year?
Turned myself in.
After you took off and didn't show up in December of '24, you didn't turn yourself in.
Last year after April, I turned myself in for these charges.
Okay. So you test positive on May 19th for amphetamine, methamphetamine, and fentanyl, right?
Right.
You were just recreationally using methamphetamine?
I don't know why the fentanyl and methamphetamine is in there.
What?
It's only recreationally used cocaine.
Well, there was no positive test for cocaine. There was a positive test for amphetamine, methamphetamine, and fentanyl.
I can't explain that.
Well, I can explain it. You want me to explain it? Do you want me to explain it? Do you want me to explain it?
Sure.
You took meth and there was fentanyl in it. That's the explanation. So,
O'Donnell's a genius. He figured it out. He solved the mystery.
so you like to use meth, you like to use pot, you like to use cocaine, and you don't have a problem because you've been sitting over here for the better part of 6 months and have kicked the habit because you only use it recreationally. Is that what you're telling me? Well, I mean, if I'm boring you, we can just dispense with this and I could send you to prison.
All right, first matter is case 25-1697. This is People versus
Okay, this is just excruciating. You're going to hate it.
Harvey Jesse Lee Edward. Into the record.
Good morning, Your Honor. Brian Jackson on behalf of Mr. Edwards, who is present in the courtroom to accept the people's plea offer.
What's the nature of the plea?
Thank you. Mr. Edward will plead guilty to an added count of use of a controlled substance, methamphetamine. In return, the people will dismiss the possession charge and the habitual offender notice.
Give me a second to try and catch up with you. Mr. Edwards, sir, do you understand what's going on? Is that a yes? Yes. What's going on, sir?
I'm understanding everything that's going on. What's going on with you?
So I just asked you, so what's going on? And you tell me you understand what's going on.
I think you was talking about food.
What are we doing here today?
Yeah. I'm here to set the plea. I can't say.
Mr. Jackson, let him see if he can work his way through this, because otherwise it's really problematic. Did you want to give your appearance?
Yes, thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Thank you for being here, Mrs. L. So what is it that you're doing right now, sir? Preparing to take a plea offer?
Yeah.
And what is the nature of the plea offer? That you would be pleading guilty to the charge of use of a controlled substance.
The judge is, this judge is very, distinguished, is a good word for him. And he's doing this very calmly, very professionally. And his attorney is trying to help him, but it's just not working.
Me?
Yes.
Yeah.
Are you having trouble focusing, or what's going on?
No, it's fine. It's fine. It's just upset about it.
Why are you upset? Or are you just saying you're upset?
I'm upset about it.
Why are you upset? Does matter, which is why we're having this conversation, which is really not going that far. Because I want to make sure that I understand that it was out of the room. All of these negotiations took place without my presence, and so I'm trying to make sure that I'm protecting your rights. Because you're about to plead guilty to a criminal offense. So I want to make sure that we're not sort of rushing through this process, which is why I'm slowing everything right down to make sure that I understand and you understand that we have a mutual understanding of what we're doing. I could actually just shut this down and be done with it and accept your plea. But instead, I'm trying to make sure that you understand exactly what it is that you're doing. And it sounds like you're really wanting to try and fight with me about doing this, which doesn't make any sense. So if you could, try and look at me so I know that you hear what I'm saying. So you're about to plead guilty to a criminal offense. And this offense carries with it the possibility of you going to jail for up to a year and having a fine of $2,000. But more importantly than that, that if you're already on probation or parole, that this could be a violation of your probation or parole status. You understand that? Is that a yes?
Yeah.
So this is being recorded, so you actually have to speak loud enough to be recorded. Okay. You also understand that if you're already on probation or parole, that this could be a violation of your supervisory status with another court. Is that a yes? You also understand that this carries with it some restrictions, that your license can be suspended, that you can be ordered to pay fines and costs, so that there are other things that are possibilities with regard to this matter. You understand that? So understanding what I've said to you, do you still want to go forward with the entry of your plea? It's a simple yes or no question. You do not want to go forward. Go to the next matter. Mr. Jackson, I don't know if you want to talk to him or if you want to try and reschedule.
Yeah, there you go. Sit in jail for a while longer, jackass. All this was explained to him by his attorney, I guarantee it. The judge knows that too, but he's not having this crap on the record. And he made a very good record, and it was very appropriate through all this. Here we are.
To have this matter go to a jury trial. To give them some space, Mr. I don't know which one you guys are actually shepherding this case. Are you doing it, Mr. Chavis? You seem to be the closest.
You're for this defendant to
For this defendant.
wherever you want me to have him, we could.
Mr. Jackson, are you done with him for today, or what's going to happen?
I would like to talk to him again.
Can you provide a space for them to be?
Yes, sir.
What's our next case?
State of Michigan versus Alyssa Deloach, file 24-43182-SM.
All right, I think this is Zach's fault, and I also believe Lab Matt's fault. Well, let me check on that. But it's fun.
I do see Ms. Deloach is with us. Ms. Deloach, I believe that we adjourned probation violation hearing last time on November the 6th in order to allow you some time to complete your probationary terms. How have you done with that?
They're completed.
All right, I do have a community service sheet list that it appears that you dropped off late yesterday, indicating that you got 21 hours completed at the Traverse City Women's Resource Center. Is that correct?
Yes.
All right, and I do also have a certificate of completion of the theft awareness program that you completed on November the 6th. Is that also correct?
Yes.
I believe that the third thing that you were supposed to do was make a payment towards your balance on your fines and costs. Did you do that?
Yes, I did this morning.
All right, Ms. Hill, can you confirm that?
She made a $50 payment this morning.
Thought there was supposed to be a $100 payment.
My check was $324. $50 is what I could afford. I did call when I called the courthouse this morning to make my payment. I asked to set up a payment arrangement for $50 every 2 weeks because I just started working today They transferred me to Natasha. She did not answer the call. I emailed her and requested to set up a $50 payment, and she said that is your decision.
You understand that this morning is kind of like calling before noon at 11:59 and 59 seconds?
Correct, but also we had Veterans Day, which closed the bank, which pushed my paycheck back a day. I didn't even know what my paycheck was going to be until it came in this morning. As soon as I woke up, got paid, I called the courthouse at 8 a.m. Actually, I called at 8:13 this morning. I can't do anything when the bank is closed today and it pushes my paycheck back a day.
What you can do is budget so that you're not wondering what your paycheck is going to be. You know what's going to be there.
I also had,
Ma'am, let me finish. And you have planned for making your payments before the day that they're due. That's adulting. Do you have something else that you want to say?
I can't control when the bank closes for a day. I agreed to have my payment paid on Wednesday because that is my payday. The bank was closed today, which pushed my paycheck back today. I can't control that. As soon as my paycheck came, I made my payment.
How long have you known that the payment was due today?
Since we spoke last week. However, again, I can't control when a bank is closed. I didn't have any money until payday. I borrowed money to get my retail fraud class done. That was $105. I couldn't borrow any more money from my mom.
Why is it that it's going to take you 20 weeks at $50 a week to pay off your fines and costs when you've already been on probation for so long?
Because I was not responsible during probation.
So, in order to make up for that, why should we receive the minimum amount of $50? Why should we have to wait for that?
Because that's what I can afford. I had lost my job and I just started working again today. As of right now, that's what I can afford.
Do you have a credit card?
No.
Do you have the ability to go to a bank and get a loan?
Nope, my credit is shot.
Where are you working now?
I am back at Auto Wares, but a different location.
Is that in Traverse City?
Yes.
How many hours a week are you working there?
36.
What stops you from getting a second job?
Nothing, but either way, as of right now, $50 is all I can make. I can get a second job, but until I get a second job, $50 is what I have.
All right. How badly do you want to be off probation?
Really bad. That's why I made sure I had everything done within a week.
Well, you didn't do everything within a week. You didn't pay your $100.
I'll hang as soon as court's done. I'll call and pay the last $50 I have to my name, and have that $100 payment done. I had to pay my mom back $130 from what she loaned me for the retail fraud class. I had to make $50. I had to put gas in my vehicle so I could make it to work. And I have 60 something dollars to my name, but I will pay that $50. So that way I can get off probation and everything that was supposed to be done will be done.
So you're telling me that you needed to pay your mom back instead of the court?
Yeah, because I'm not going to let my mom not have electricity, not have heat. She sent me money from her bill money so that way I could get it done so I didn't go to jail. So yes, I did have to pay my mother back. It's not her responsibility, it's my responsibility.
All right. Well, you haven't met your responsibility here.
I have met my responsibility. I did my retail fraud class the day we got off, the day that I had court. I called my mom and asked her to send me the money. I got it done that day. I got my service completely finished.
I'm sorry, I didn't mean to interrupt you. Are you finished yet?
Yeah.
Good. I gave you an extra week because you said that you would do 3 things. You've done 2.5. You've not done 3. The recommendation was that you serve 35 days in jail. Why are you arguing with me?
Because I don't have $100. I paid what I had.
You just told me that you could pay an extra $50 if I was going to put you in jail.
Yeah, if I had to. $50 is all I have to my name until I
You had to. That was the whole point. The whole point of giving you an extra week was that you had to. It was not a suggestion.
Then I will call the court and pay $50.
Thank you. Was that so difficult?
No.
You have till the end of the day to get that $50 here. Otherwise, I'm issuing an order that you go to jail for 35 days because I've already given you all the grace that you're going to get. If the money is not in the courthouse by the end of business today, the order will issue. Thank you. That's all for today.
Well, that was fun. I've got a late one. Let me see here. I've got a late edition from Melissa. Let's see what's going on here.
Okay, thank you. Your Honor, if I can break out with Miss Meridi. All right. Ms. Tortorello is in breakout room number 3. Ms. Meridi is going into breakout room number 3.
Excuse me, Judge.
Yes.
I did change my name, but I guess it's still showing Ben.
It is. What's your name, sir?
Benjamin White. I already done changed it, but it's still showing it as Ben.
I guess it's the growth case that we're waiting for.
WYCHE.
There you go.
Thank you.
You're welcome.
This is still a live stream, and I'm doing it on the fly, so I didn't get the beginning perfect, like I usually do. I can't wait to hear from Dre.
Hello.
Yeah.
Yeah, so I'm not sure if I'm in the correct vicinity. I'm trying to find out. My name is Draker Gross. Am I in the right courtroom?
Sir, if you are, you would be in the 1 o'clock calendar. We're on the 11 o'clock calendar. So right now, I don't know. Look at your paperwork.
Can you find out?
Can you look at your paperwork?
I know my paperwork. I'm supposed to be scheduled at 11 o'clock.
At what?
At 11 o'clock. I'm scheduled.
Oh, you're the person that got the bench warrant bond forfeiture for not being here on time.
Oh, really? Really? Oh, really?
Yes, sir.
Okay. So, Draco Gross, I got a bench warrant. Why? Because I'm sitting here talking with you.
Mr. Gross, are you under the influence of anything at this time?
No, ma'am, I'm not. I just talk this way.
You're just
Okay,
a baseline
well,
a-hole.
that's fine. Your attorney will be speaking with you as soon as she comes out of the breakout room. Please mute your device.
Okay. Yeah. I'm here. I've been here for
Not,
over an hour.
not when I called your name, sir.
Ma'am, I've been here. That's what I'm saying. I popped in just by luck.
Okay, sir.
I've been here. Don't put a bench warrant out for me, ma'am. I've been here.
Okay, sir.
All right, so I got a bench warrant.
Mr. Gross, wait for your attorney, okay?
All right. Do I have a bench warrant?
Mr. Gross, wait for your attorney, okay?
Okay. Okay, I will.
Hey, Ms. Judge, I just have a question. This is Kiara Claret.
Yes, ma'am.
Am I just waiting, or am I supposed to be in a breakout room? Because
Okay,
I know
ladies
I
and
know.
gentlemen, we have 2 attorneys on the defense side. We have 1 attorney on the state side. The state's attorney has to be present for every plea that we take. The 2 attorneys on the defense side are splitting things up, but they are only able to speak to 1 person at a time. They may call you, they may ask for a breakout room. At this time, both of the state's attorneys are speaking with clients, and they're going to move to the next of people on their list as soon as they come back. So they'll make announcements. Right now, nothing is going on. We're all just being quiet and waiting.
Okay, yeah, I was just trying to make sure because I know you had called my name before, but okay, thank you.
I've called everybody's name one time, but not for a plea or a resolution. Your attorney is going to make an announcement, and then we'll move forward.
He is something, isn't he? And I haven't seen this yet, but it's the wrong judge. It is the wrong judge for this crap.
Let me call this lady, because guess what? I ain't got time for this shit. Because guess what?
All right, so Ms. Bing, Ms. Arnold, if you're on, I believe that Mr. Gross is under the influence. Mr. Lynch, Ms. Tortorello, I believe he's under the influence. He's yelling at the camera. I've muted him at this time. I'm going to issue a bench warrant bond forfeiture, and we can deal with it on the jail side. Thank you.
Well played. But wait, there's more. All right. Tell me when it's done, Alyssa. I like it. She didn't respond to any of that. She just hit the mute button and then said, this appearance isn't happening today. Old drunkie just needs to come down, get picked up, and we'll pull him over here from the jail cell and talk about it. Maybe he'll be sober then.
Hi, Judge. I'm sorry. I was outside of the courtroom, but I understand maybe Lister Holden Dennis needs to
Mr. Gross appeared. He is acting erratic. He sounds like his speech is slurred. And he sounds like he is under the influence of an intoxicant. Therefore, the court has muted him once he started using expletives. And we'll move forward with him on the jail calendar because I'm going to leave the bench warrant bond forfeiture in place.
Okay, Judge. For right now, I'm just gonna digest that information and we'll figure out what the next.
If you look
steps
at the screen, he's still yelling and emoting.
I do observe that.
I do observe.
Okay. Hey, Mr. Gross, sorry. I think right now a good idea would be to turn off your camera if you're having a conversation with somebody from our office, and we'll go from there, okay? But Judge, while I am here, I do have one additional announcement.
Go ahead.
Tamika Williams, I'm sorry, we already made that. I'm sorry. Kevin Williams does wish to enter a not guilty plea today.
I don't know. Am I done?
1 second. All right, Mr. Williams, you have bond conditions that require you to not have contact with a particular person and possibly not to go back to a particular location. Please make sure you adhere to those conditions. If you do not know what your bond conditions are, get a copy of your bond conditions through the state court clerk's office for Clayton County. So Clayton County State Court Clerk, if you go on the website, they, I think, have a QR code that you can scan that will help you access the information. But if you were to have contact with those individuals, you could be arrested, your bond could be revoked, you could remain in jail until your case is resolved. You could be charged with additional misdemeanors or felonies. Do you understand?
Yes, ma'am.
All right, thank you. You're free to
Thank
go
you.
this time. Keep in touch with your attorney.
All right, thank you.
Mhm.
I think I know what he's saying. And I think it's this.
I think this is a Pharisee of mismalice of justice.
All right, quorum 304.
Yes, Your Honor.
All right, at this time, I'm removing Mr. Gross from the Zoom. He won't be able to log back in.
Judge,
Yes.
who didn't Attorney Colorado said needed a conflict attorney?
Hold on a second. She said it would be one of the K.
There you have it. There you have it. We started with a substitute emergency. Then we went through the stuff I had, and then we had a nice add-on from Alyssa. Good times, good stuff. Thank y'all for coming out. I appreciate it. That one got a little longer than I expected, but it was all top-notch, high-quality entertainment here at Law Talk with Mike. I'll see you soon.